This is one of those courtroom moments where the gravity doesn't hit you right away, but once it does, there's no unseeing it. What starts as a procedural roll call quickly turns into a high-stakes plea hearing involving 2 felony counts, with dramatically different punishment ranges. On one side, the state of Texas. On the other, Mr. Soraniano, facing a first-degree felony with a potential sentence of 5 years to life, alongside a third-degree felony carrying up to 10 years. The outcome here isn't about guilt. That's already decided. This hearing is about how much of a life remains on the other side of prison walls. Pay close attention to how carefully the judge walks through each right, each waiver, and each consequence. Because once this plea is accepted, there's no rewind button. And the biggest question hanging over this courtroom is simple. Is this negotiated punishment justice or just damage control?
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
All right, we can go off the record. So here's the question. You are proceeding on 2 counts, one as a third degree and one as a first degree?
Yes, Your Honor.
So you all have in your plea bargain page, you need to signify what the plea is for the first degree and what it is for the third degree, because you all have 18 years. So if you all will correct that.
Just want it to run concurrent, Your Honor.
No. If you'll say what is the plea. So for the first degree, you all have agreed to 18 years?
Correct.
Yes, Your Honor.
And so I'll need to know what the plea is for the second degree.
Third degree.
I'm sorry, the third degree. Correct.
Did we just do the third concurrent with the first?
No, I mean, you just put down what years did y'all agree on for the third degree?
2.
Years.
Mm-hmm.
All right, Mr. Soraniano, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
This exchange may sound technical, but it's legally critical. It just stops the proceedings because the plea paperwork is unclear, and that's not a small issue. When multiple felony counts are involved, each charge must have a clear, defined sentence, even if the parties intend for them to run concurrently. Here, the defense and prosecution agreed to 18 years on the first-degree felony and 2 years on the third-degree felony, served at the same time. That distinction matters because concurrent sentences don't merge, they coexist. If paperwork is sloppy, it opens the door to appeals, resentencing, or even reversals. The judge is protecting the integrity of the plea and the record. This is a reminder that in criminal court, precision is power. Do you think defendants truly understand how much rides on paperwork like this, or it'll just blur together under pressure?
Time, we're off the record. What amount of time are you all asking for in the third degree? I can't read this.
It should be 2.
Okay.
Yes, Your Honor. 2 on the third, 18 on the first, concurrent.
All right. Do y'all want to initial this for me?
What if we did up top? Your Honor?
Sure.
Okay.
All right. Did you understand in count 1, your charge is possession?
Yes, Your Honor.
And count 2, you're charged with, in count 1, you're charged with a first degree felony. Range of punishment is anywhere from 5 to 99 years or life in prison. And count 2, you're charged with as a third degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
If you'll sign. Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
According to the plea, count 1, you're to be sentenced to 18 years in the prison. Count 2, you're to be sentenced to 2 years in the prison. They're requesting that the counts run concurrently. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
It is, Judge.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
By signing that, you're waiving your right.
This exchange may sound technical, but it's legally critical. It just stops the proceedings because the plea paperwork is unclear, and that's not a small issue. When multiple felony counts are involved, each charge must have a clear, defined sentence, even if the parties intend for them to run concurrently. Here, the defense and prosecution agreed to 18 years on the first-degree felony and 2 years on the third-degree felony, served at the same time. That distinction matters because concurrent sentences don't merge, they coexist. If paperwork is sloppy, it opens the door to appeals, resentencing, or even reversals. The judge is protecting the integrity of the plea and the record. This is a reminder that in criminal court, precision is power. Do you think defendants truly understand how much rides on paperwork like this, or it'll just blur together under pressure?
All right, why should I follow this plea bargain agreement?
Your Honor, I would ask you to follow the plea bargain agreement. The first degree charge stems from an incident where he will be likely charged in a different county. The other possession charge is probably on the spectrum of what I see, the least offensive.
None of these cases are good, but as far as the spectrum, it's a lesser one. And these were primarily photos. I don't know if he took them or he had them on his phone or nap, but there was a minimum number. There wasn't a tremendous number of them. So it's a substantial amount of time for this. It's not that kind of stuff.
All right. In count 1, the court will sentence you to 18 years. In count 2, the court will sentence you to 2 years. Court will give you credit for any time served. Count 1 and count 2 legally must run concurrently. There's to be no residing in households with minors. There's to be no contact with minors. Did you review the document entitled trial?
This is the point of no return. The judge methodically explains the rights being surrendered, the right to a jury trial, to confront witnesses, to remain silent, and most significantly, the right to appeal. When Mr. Soraniano pleads guilty to both counts, he isn't just admitting responsibility, he's locking in consequences. The court makes it crystal clear that if the plea bargain is followed, there will be no permission to appeal. This is where the system trades certainty for finality. The defendant avoids a potentially harsher sentence, but gives up future challenges. It's a calculated risk and one that many defendants take under immense pressure. Watching this unfold raises a tough question. Is this an informed decision, or the least painful option in a room with no good choices?